Imagine waking up in the morning, maybe pulling out your cell phone and check your bank account, just see how much money you got in there, and it has a zero on there. All of your money is gone. All of your money is gone. First thing that will probably come to your mind is, did someone get my debit card, or did someone get my bank account and scam me out of the money? You know, what happened? Like, all of these things would probably be going through your mind. And then once you got a chance, you got yourself together, you called your bank customer service hotline, and you get someone on the line, and then they tell you that a debt collection attorney withdrew the money out of your account. How would that make you feel? Because they legally were able to take the money out of the account. This is something that has happened to an individual, wrote to me from YouTube, very distressed, very upset, cannot believe that it happened. He stated that once he found out that it was the debt collector who took the money, that all of the decisions that he made up to that point came to him in a second, to where he knew that he had made mistakes going down the line that could have avoided that situation, could have avoided it. So now, stuck with not being able to pay the rent, not being able to pay the car note, not being able to put food on the table, in a situation to where the debt collector was able to legally take the money because he did not respond to a court summons. Default judgment in his name, didn't do anything when he got the paperwork for the default judgment, and then all of a sudden, a month later, a writ of garnishment to take money out of his bank account. Now, I have videos showing how they know how to take money out of your account. You know, they look at your credit reports. I'll just explain it. They look at your credit reports so they can see what you're paying on. They look at your credit reports to see you're paying your car, you're paying maybe your mortgage, you're paying some credit cards. They could see the cycle that you're on paying your bills. So they're just like this. Get the writ, put that order in at the bank when they estimate that you're going to get your paycheck, and then all of that money is gone legally. And here's the thing about it, is that the bank is not going to tell you anything about this. Like, these are court orders, and they're just going to take. As a matter of fact, some of the time the banks really don't know what it's about, other than that the court ordered that this money be transferred to this company or debt collection firm. That's basically, and they're just going to follow. And it makes it very difficult, because it's like, when they get a court order, they're just going to follow it, because they have banking regulators. They don't want to be out of compliance with anything that the court says that they have to do. So you don't want to wake up in the morning where your money is gone. And like I said, the gentleman in a snap second knew all of the bad decisions that he made that could have avoided this situation. So let's start with bad decision number one. And there's a lot of videos on YouTube telling people not to do this. And I'm telling you that you need to do it, because we want to avoid these types of situations. Individual got a letter from a debt collector stating that the debt collection company purchased an old debt that he had. He decided to just disregard it, which is something that I've done in the past. I know that you've probably done it. Other people have done it. But I'm here to tell you that that is something that you should not disregard. The first thing that they're able to do when you disregard that, and this is according to the Fair Debt Collection Practices Act, when they send you that letter, it's called a dunning letter. You have 30 days to respond to it. Now, there's certain legal things that they have to do have in that letter, And that I have a video for that, but there's certain legal things they have to do to make that letter correct when they send it to you, or compliant when they send it to you. But if you don't respond to that letter, you're giving them permission to put that information on your credit reports. So a lot of people will be like, well, how did they put that on my credit reports? I never did anything with them. They were able to put that information on your credit reports because you didn't respond to them within that 30 days. It tells you right in that letter that you have the right to dispute any part of it, a portion of that debt, a portion of whatever that whole letter is about, and or all of it. If you do that, they will not be able to place on your credit reports. And if they do place your credit reports, even if the debt is something that you would have had to pay, they're out of compliance and they cannot place that on there because you put a formal dispute on that about that debt that they're claiming that you have to pay. So that's mistake number one. If you don't respond, you're allowing them to place that information on your credit reports. And now it puts you into a whole nother fight that you could have avoided if you just would have responded. Now, you do have to respond appropriately, because if you don't respond the right way, they're going to just disregard your response. You do need to send that response certified mail, because you don't want them to pretend like they didn't get it. You want to make sure that you know when they got it, that you responded within the appropriate amount of time before that 30 days. And then you want to look at your credit reports, get a paid monitoring service, because you want to see what they do from when you make that dispute. Because, and this is some of this stuff is where you have to sit there and it's so tedious, and I understand that, but these are the things that you have to do. These are things that we have to do on a daily basis here at the Credit Repair Shop. So when the debt collector gets your dispute of the debt, and that needs to be done the right way, or they're going to just disregard it. And don't worry, I'm going to give you a letter that you could utilize for that. So when you get that debt, though, you got to first make sure that debt is not past the legal statute of limitations to collect. Because if it is, you don't have to do a debt validation. You don't have to do none of that stuff. You just have to notify them that the debt is past the legal statute of limitations to collect. I'm going to give you a letter for that at the end of this video. But for right now, we're going to just move forward as if that debt is not past the legal statute of limitations to collect, because I'm going to walk you through the different things that can happen so you can avoid what happened to the gentleman that had his bank account garnished of all of his money. So if the debt is not past legal statute of limitations, you do a proper dispute, that sometimes the debt could go away. And I'm going to talk about that with the response of the court summons on the things that you need to watch out for. But you can be proactive in your dispute of the debt to put that debt collector on notice that it's not going to be just something where they just walk over you, that you're going to fight every step of the way, all the way up if they decide to take you to court. So, and I'm going to give you a letter for that, so don't worry, but just follow me. So when you send that dispute to them, it's going to usually put that into a 90-day grace period where there's nothing that can be done for 90 days. Now, if the debt collector purchased the debt, there's a number of things that they're going to have to make sure that they have if they're going to move forward with taking you to court. And I'm going to speak on those in a second. If the debt collector is collecting it for the original creditor, that 90-day window is going to be what they use for them to be able to talk to the original creditor and say, hey, these are the issues that your client came up with regarding this debt. We don't really know too much other than you gave us a few documents and you said this is the amount that you want us to collect. We have a job as a debt collection company. Even though we're doing the work for you and you're sending it over to us, we have to verify it. And that is true. Debt collectors, if they're collecting it for other companies, they still have to go through a verification, validation process. They cannot just go out there and just take the word of their client, because they are under certain restrictions that they have to follow to be able to collect debt for others. Quote, others mean other companies. So they have to follow the Fair Debt Collections Practices Act, regardless if they're bought the debt or if they got the debt and they're just collecting it for their client. So here are some of the things that you need to watch out for if they go to the next step, because after that 90 days, they're going to make a determination on if they want to move forward. Now, it could either be the debt collector saying, we want to move forward, because during that 90 days, they could do their own investigations by looking at your credit reports to see what you're paying on, to see if you potentially have money to be able to pay this, to pay if they take you to court and win. Also, some of the things that they will do, which happened to a client, is that they will go, depending on the amount of the debt, they will actually go to your house and take pictures of stuff. I've had clients report to me, somebody was taking pictures of my car, somebody was taking pictures of my house. I don't know who it was, and I told them it was someone who works for the debt collector. There are companies that go out and do this because what they're trying to do is to see if there's going to be any way that they can collect on the debt. Now, I'm not saying that they're going to try to take your assets. Now, if it's a business collection, potentially. But if it's just regular civil, not business, what they do is they're trying to make a determination on how you are living so they can make a determination on if they want to move forward with the lawsuit. Now, I could tell you that probably 1-2 years ago, if it wasn't $1,200, $1,500 and up, these debt collection companies were not really going after people in court. They would just try all means of, calling, sending letters, doing all that they could do. Now what they're doing is they're like, hey, if people aren't showing up, we're going to let the debt balloon up and go in there. It doesn't matter. I've seen some for as low as $600 going into court, over $600 for old credit card debt from for a debt that they purchased for $600. Because what they're looking at, their game plan is like, if it doesn't matter if it's $600, $1,200, or $20,000, if we could get those payments coming in, that's all that the debt collector is thinking about, getting those payments. So now what I'm seeing is that it doesn't matter what amount. I haven't seen anything less than $500, but they're going after people trying to get it because most people don't respond, or most people don't respond appropriately. So let's say that 90-day period passes, and now what's the next step that they're going to take? They're going to potentially take you to court. After they've done whatever they're going to do with their investigations, they'll use skip tracing to look at your credit reports and to see how much, how much stuff you're paying on, so they can estimate how much money you might potentially be making if you're paying a mortgage, if your rent is being reported, maybe you got some apps, your cell phone. See, all of this stuff is crazy. All of the stuff that used to not get recorded that we would pay on, now there's all of these different programs to get that stuff reported. So now it kind of gives a window of all of the different things that you're paying on. So it's like those are tools that are very good to get credit for things that you've been paying on that never reported to your credit reports, but it also gives a window to debt collectors to see what you are paying on, and they can estimate, how much money you're potentially making. So, but the next step, if they decide to take you to court, and this is where that gentleman, this was the next mistake that he made, is that he disregarded that summons. They were knocking on the door, trying to serve him with that summons, and he just disregarded it and then never showed up to court and got a default judgment. And just so you know, some people don't know this. If you get summons to court, If they don't serve it to you, they will publish it in a newspaper. Some people were shocked about that. I had a young lady who said, I just don't want this stuff to go public. And I said, if you don't want it to go public, you might want to get that summons, because the next step that they're going to do to be compliant with the court is to put a public notice in your name that they're trying to summons you to court. So you could look in your newspaper. I know there's not too many daily newspapers that are out there. Now some of the courts are allowing it to be published online. And there's different types of online publications that they're allowing those public notices to be published. And that's going to be the new world that we live in. So it's going to even be more chances that your name could pop up, because what they're going to do is they're going to advertise it out. Here's public notices, just in case you're being summoned to court. Here's public notice if someone is trying to get a name change. Here's a public notice for a company that is filing Chapter 11 or filing Chapter 7, or, whatever the business filing bankruptcy. And any people that are filing bankruptcy, they're going to have ways to publish those. And the way that it was done in the past is that they would just post those notices in daily newspapers. So if they end up taking you to court, they publish it or they get it in your hand, don't make this mistake. You need to get that summons and you need to respond to that court summons. Because if you don't, the way that I've always seen it, if you don't respond to the court summons, you're actually making the court against you and the debt collector against you. It's like you got two people against you rather than one, because the court is there. They're like this neutral party. And if one of the parties isn't responding to them, it's like, well, you don't respect the court. Even though it has nothing with not respecting the court, a lot of people are afraid. They don't know what to do. They don't know what to say. So it's not really about disrespecting the court, but that's the way the court looks at it. It's like, you didn't show up, so we're going to, you didn't come to argue your side, so we're going to give it to the plaintiff. They get these default judgments, and then they go back in the court and they get the garnishment order to either garnish a paycheck, or they just say, we don't want to garnish a paycheck. We want to garnish the bank account, and they can do that. They have those options to do that. So now let's talk about some of the things that you should look for when a debt collector is suing you with over a debt that they purchase. So you need to set up an affirmative defense to counter everything that the debt collector is saying in the court summons, which is the allegations that they're putting towards you. So now there's certain spots where you're just going to say you admit or you deny, or deny not enough information. There's certain spots for that. And that when you look on the summons, you'll see that they'll ask questions like, do you reside in this county? If you don't reside in that county, they can't sue you if this is civil. If it's a business, they can sue you just about anywhere that you've done business. But if it's not business, they have to sue you in the county that you reside in when it's just a personal account. So that's the first thing that you need to look at. If you do not reside in that county, you can get that case dismissed based off of improper venue. You can just get it dismissed. I had a YouTuber subscriber who said that he's getting sued in the county that he's in and in another county. And I was like, well, the one that's in the other county, you can get that one dismissed just because of improper venue if it's not business. So now, when you write your affirmative defense, so you responded, admit, deny to the allegations that they set forth with you, there's going to be one specific or a few lines where they're going to specifically talk about the amount that they say that you owe. I call it the claimed amount. They claim you owe $5,000. They claim you owe them that money. That's where you're going to want to make sure that you respond back that they need to prove how they came up with that amount of money that they claim that you owe. They can't just walk up to you and say, you owe $5,000. They can't just say, here go two statements that you owe $5,000. But if you don't respond, They can get a default judgment based on those two statements and them saying that you owe $5,000 and that they purchased it from a previous creditor. So you want to make sure. So let's just go down the line on what we want to ask, what we want to put in our response, our affirmative defense. This is how you're going to fight back against debt collectors, is that we want them to prove the contract, proof of contract between you and them with your signature on there, that you're doing business with them. You already know what they're going to try to do. They're going to try to say, hey, we got this contract that we bought the debt and that we bought it from them, and now we assume or the debt has been assigned to us. If it's a debt collector that's collecting for another, for the original creditor, then they're going to, get the information from the original creditor. But you still want to make them prove that with your signature on there. You want to get all that information because you have a right to do it. You have a right to ask for it, no matter if the debt is yours. Next thing is you want to look at, get something that states that they have a right to view your personal information, your private data. There's all of these things about ID theft and all of the stuff that's going on right now with sharing data, with sharing private information. You want to see something that allowed that bridge from either the original creditor to get it over to them when they purchased it and to have your private information, or something that you signed from the original creditor, period. It's going to be that they could share it with people, with companies that purchased the debt, or that they could share it with companies that are collecting for them. You want to have them give you that information. Next thing that you want to do is you want to get a complete account number. Now, I've seen that they started to get those complete account numbers. But you want to get the complete account number. Maybe you had a few accounts with that original creditor. You want to make sure that that is something that you can verify. If they can't verify it, how can you verify it? And it's up to them to make their case, not up to you to make their case. Next thing is you want to, there's going to be a bill of sale that they give you when they buy the portfolio. And here's the crazy thing, is that they never have your name on that purchase of the portfolio. They're just going to have like a file number. So you can challenge that the portfolio doesn't have your name specifically on there. So that's one thing that you could challenge. But also, you will see, if you've ever seen these bill of sales, it'll say that the original creditor does not guarantee that the information is 100% accurate. They will just flat out say that. There's been debt portfolios that's been sold that people were in bankruptcy. They wasn't supposed to sell them. People had the balances were inaccurate. People who had paid off accounts were in there. You never know. They're just buying a file with all of these names on there, and some of the times mistakes are made. But even if the mistakes are not made, there's still things that you can challenge by them just saying on there with their own words, with their own document, that the portfolio is not 100% accurate. If it's not 100% accurate, how can you say, and this is the debt collector, you're talking to them, if your document says that you cannot, that the original creditor said to you, we cannot guarantee that this is 100% accurate, and then you're coming to us to try to collect on this debt, what portion is not accurate? Is it what you're getting to me? Is it what you're doing with somebody else? How about this? Just give me all of the information to prove the amount that you claim that I owe. Every statement from day one when I started that account. And we'll know if it's 100% accurate. 9 times out of 10, they won't be able to do that. The next thing is, and that goes into what I just said, but this would be the next line, is that you want them to give you all the payments, credits, interest rates, rewards, disputes, everything. Because they'll come up with this little thing saying, well, is there an amount that you dispute? Is there an amount that you dispute? In which we would have already had that on record if we would have followed with mistake number 1 that the gentleman made. Is there anything that you dispute? They will actually ask you that. Okay, well, I dispute the whole thing then. And why do you dispute the whole thing? Because you have not given me all of the information to come up with this number here. You just provided a couple of statements. Give me more so I can see this. Give me all of the payments that I made so I can, minus off what you're claiming that I owe. I want to start from day one, see all of the charges, see all of the payments, see all of the credits, the rewards, everything, and then I'll see the amount that I owe, if I owe anything. If you can't get that, I don't see how you can have your case. Now, the next thing that we want to do is we want to make sure if it's a debt that was purchased by the original creditor. And I will even throw in if it's a debt that is still with the original creditor that has been there for an extended period of time, to make sure that they did not file a 1099-C. In some situations, we've seen where original creditors have filed a 1099-C to cancel the debt, and that debt was accidentally thrown into the debt portfolio. Now, one way that you can make sure that they didn't do it is you can call them up, and then you should call the IRS, because they have to file that with the IRS. I know it takes work, it takes footwork, but you got to do it. But you should also put that in your response for your court summons, in your affirmative defense. Now, something that I've seen with Lending Club and some of these other ones, other lending companies, where there's like 50, 60 different LLCs and I don't want to say not foundations, but different companies that are involved, credit unions that are in these lending clubs, and all of them are signing off on a debt that was purchased by a debt collector. Now, if all of those companies, now you're going to tell me that you got 50 companies that are involved in this, and why did every one of them have to sign off on that debt purchase? You telling me that none of those companies potentially filed a 1099-C for that debt? We don't know, but I just say that when I see those types of court summons where it's like it lists all of these companies that are involved in that loan process, and they have to sign off on the sale of that debt, one of the companies in there potentially filed a 1099-C, and if one of them filed it, how much did they file it for? And if two of them filed it, how much did they file it for? Let's just say the debt was $5,000, and you got 50 companies that signed off on the sale of that debt. This is documents that I see from these lending clubs. So if you got 50 companies signing off on an affidavit that they sold a debt to a debt collector, giving away their interest, you're telling me that none of those companies filed a 1099-C. And if, let's just say two of them did, what is the amount that they filed it for? What if all of them filed it? What is the amount that they filed? Do all of them get to file $5,000 1099-Cs to have the debt written off? So it's very confusing when I see those, and I don't believe, we have not lost any of the responses that have been written for those lending clubs. Have never, the clients have never lost, because it's very confusing when a judge sees that and they see all of these companies. They're like, all of these companies were involved in loaning this money to this individual, and then all of these companies had to sign off in the sale of this debt, and none of these companies filed a 1099-C. And if any of them did, how much was it for? It's very confusing on those. I'm still trying to get to the bottom to why they do that. And then number 7, in your response, something that I talk about with the Dunning letter, if you did not get a Dunning letter, sometimes people don't get them for any various reasons. Maybe you moved or whatever happened. You just did not get it. It is required by them by law to give you the opportunity to dispute any or part of that debt, and that they have to send that. Before they move forward, they have to make that demand. They can't just go to court. And they do this all the time because they get away with it. Next thing is that you want to, let's see here, supporting documents. So there's a conformity document that they have to show that they got all of the documents and that they conform to the way that they're supposed to conform when they're purchasing documents. This mainly goes to debt collectors who buy debt. There's going to be that bill of sale. You want to make sure that that's right. Make sure the dates are right. Make sure that that plaintiff, that debt collection company, is actually listed on that bill of sale. We've seen where it's been purchased by one debt collector, sold to another. If a debt collection company purchased it and sold it to another, you want to look at the fine print, because there's some companies that sell debt that say, we don't want you to buy it and sell it to another debt collector because we don't want to be responsible for what that debt collector that we don't know that you sold it to does with that debt, the way that they contact people. We don't want to be, we don't want to have any repercussions from the way that they do it. We sold it to you. You collect it. If you can't collect it, you give it back to us. That is actually wrote in some of the contracts. Now, not all of them are not like that, but that's wrote in some of the contracts where they say, you sell it, we sell it to you, you collect on it. Don't sell it to someone else. Now, there are certain companies, Sherman, Portfolio Recovery, Resurgent, they'll buy it, give it to one of their, Sherman and Sherman Acquisition 1, Sherman 2, all of those companies, Resurgent, they're all really pushing stuff mostly to LV&V, which is really part of their company. They just try to separate it so if LV&V gets sued, they don't get sued. They're able to continue doing what they're going to do. They can start another LLC to pump out, to buy debt and to collect on it. So those are the things that you want to fight. I do have videos where I go into more detail. I put it on the whiteboard on stuff, but that right there, if you could do that, you can avoid what this individual had ran into, waking up with money taken out of their bank account. Because when you respond to the court, at least you will have the opportunity to defend yourself, and you could win, or you could get into an opportunity where they'll make you a settlement offer, and you can do that. But at least you're being proactive. You don't want to wake up in the morning, have your money gone. All right, if you need help with a court summons, there's a link below this video. You can go to my website, thecreditrepairshop.com, in the live chat, put your question about your court summons, upload it for review, and then we'll let you know how we can help you. If you already have a default judgment against you, we can help you reopen that. There's a certain time frame, but we can look at that also for you. Go to the website in the live chat. Let us know what's going on. If you need help with your credit, please visit us at thecreditrepairshop.com. Watch video, What Makes Us Different, so you can see my 8-point validation process, my 2-phase settlement process. If you need your credit reports and scores, go to the website, your3scores.com to grab your TransUnion, Equifax, and Experian credit reports and all 3 scores. You need that to be able to know where you're at, who's putting stuff on your credit. You need to know what's going on with your credit all the time, because you don't want to have something come that you didn't know about. If you have debt collectors coming after you, you can stop them early. Grab my 3-pack of letters. Statute of limitations letter for debt that is past the legal statute of limitations to collect, debt validation letter, and cease and desist collection activities letter. Use the one that's appropriate for your situation. I put instructions on there. I do ask for a donation on those. It can literally save you time, money, and frustration. I have people all the time write to me saying that I stopped the debt collector by doing that. I did it the right way and it stopped them. Thank you for your time. Please subscribe to the channel. Post your questions and comments. This is Stephen A. Williams, President and founder of the Credit Repair.